Before employing a foreigner in China, you should note that it is not unconditionally free to employ a foreigner for all posts.
This is Complex Made Easy with Dezan Shira Associates, in partnership with Laytons ETL.
First of all, it is very important to determine the type of relationship. Identifying the relationship correctly will help you in applying the correct laws and ensure your compliance. Employment relationship. The term in Chinese is 劳动关系. The more direct translation is labor relationship. Labor relationship 劳动关系 is different from 劳务关系. The latter's proper translation is service relationship. These two relationships are respectively applied with different laws. Labor relationship applies to labor law and labor contract law, whereas service relationship applies to the chapter of contracts under the civil code. But these two relationships are easily mixed up and mistaken. How to distinguish them? There are several features you could tell the difference between these terms. First, under a labor relationship, the employer cannot be a natural person. It must be a duly registered organization such as a company, an individual economic organization, a private non-enterprise entity, etc. For example, an architecture design company employing an architect to work for the company. Under a service relationship, the hiring party can not only be the organizations I just mentioned, but also can be a natural person. For example, a new mother who hires a babysitter to help with nursing the newborn baby. Normally, a labor relationship is expected to be stable with a longer term. It is not based on a temporary project, but based on the employer's continuous need for manpower. For example, an architecture design company has continuous projects, so it needs to employ stable architects to continuously work for the company. But a service relationship is comparatively contingent, flexible, and may be based on temporary needs. For example, an advertising company is required by its clients to create a poster where there should be some good-looking and attractive architectures. But this advertising company does not have the expertise in the architecture area. So the advertising company hires a freelancer architect to provide a one-off service to create a poster. Third, the payment cycle and payment method are different. Under a labor relationship, the salary payable to an employee is once a month in most cases. And there is a minimum salary standard required by local regulations. For example, the architect working at the architecture design company receives his salaries by the end of every month. The salary amount does not fluctuate even if the company is in its off-season. But under a service relationship, the amount of service fee is negotiable and depends much on the quality of delivered work or the time spent on the services. And the timing of payment is also negotiable. It will be payable after the completion of service, as long as it is reasonable and accepted by the service provider.
The difference between employees and workers and the self-employed in English law is quite an important one. Employees are people who are provided with contract of employment and render their services on a weekly basis, usually 35, 40 hours a week. and they actually do what an employer asks them to do. So they're obliged to actually follow instructions. Workers are a slightly more anomalous type of employee. They provide services personally. However, they have no obligation to actually provide those services. It's a type of category of employee that suits those sorts of workers who want to do work on an ad hoc basis. So where, for example, you're looking for just a little bit of help now and again, that's how a worker would be classified. And their rights in employment law are there, but they are lesser rights than those of employees. So effectively, employees have full rights and workers have slightly less, more watered down rights, or have watered down rights. Then there's the distinct category of the self-employed. Now, the self-employed are those who are actually providing services on their own account and are taking a real business risk. This is quite an important area for an employer to consider, because if someone isn't genuinely self-employed, then the obligation would be to deduct tax and national insurance, and that obligation primarily will fall on the employer first. And therefore, if the tax authorities deem someone to be an employee, not self-employed, then that is a real headache for the employer. So that's something that really has to be examined extremely carefully. And genuine self-employed are people who take a commercial risk. If they're just turning up 9 to 5, day in, day out, that is not a commercial risk, and they will be deemed employees. And they themselves could claim that and bring claims for being employees, and that's a real problem. So those are the three types of workers or employees that you find in English law, and should be thought about right at the outset of any relationship, and shouldn't be left for something to be sorted out afterwards, because it's far more difficult to deal with after the event than it is before you actually employ someone.
The UK.Ireland desk at Dezan Shira Associates assists British businesses with market entry, legal, finance and HR in Asia. For expert advice on employing people in China or UK investment into Asia, contact us at UK.Ireland-Shira.com. To stay up to date with the latest investment news into Asia, visit and subscribe to asiabriefing.com.